Laura, hi, lovely to be with you today, and it's very good to get a chance to discuss with you something which has troubled real estate practitioners across the board, whether it's transactional, leasehold enfranchisement or in pure litigation, and that is the Building Safety Act. I think we all agree, since the Act was implemented in 2022, it has caused nothing but headaches for both our clients and for practitioners. And of course, it's a new bit of legislation, the case law is evolving. But today we're going to have a chat about the certification processes, and I just wanted to run a particular scenario past you to get your views on this. It relates to quite a common setup in central London, which is a higher risk building. It's 20 metres in height. The original developer has actually retained the freehold interest in those premises, and we act for the intermediate landlord who has the direct reversion, so is the immediate landlord of the residential flats within the development. There's some shops on the ground floor. One of my colleagues, in the usual way, has received an application for licence to assign, and in that context has also received a request for a landlord's certificate. And I just wondered if you could talk us through what that is.
Absolutely. I think before we talk about landlord certificates, it's actually probably worth just very briefly going back to basics and talking about the origins of the Building Safety Act. It was introduced in order to implement the recommendations in the Hackett report, which followed the Grenfell tragedy.
Huge
its
news.
Scope is hugely wide-ranging, and the provisions are essentially aimed at making homes safer. The Act includes, amongst other things, extensive provisions governing the relationship between leaseholders and their landlords and their respective duties and liabilities in relation to building safety matters.
Yeah.
One particular section of the Act contains a plethora of protections for leaseholders from being required to contribute towards the costs that a landlord incurs in remedying building safety defects within the building. And it's that particular section that we're dealing with here, given the context that you've discussed, where there's been a request for a landlord certificate.
And is it worth mentioning as well that in terms of building safety risk, it's not purely the cladding, which of course was the primary issue in the very tragic case of the Grenfell, but any fire safety risk, so it's quite wide ranging, isn't it?
Yes, exactly, Anna. It's fire safety risks and actually structural risks.
Right.
As well. So going back to the landlord certificate, it's a prescribed form that the landlord has to complete in certain circumstances, the purpose of which is really to assist a leaseholder in identifying whether or not it is obliged to pay for those remediation costs through the service charge.
Yeah.
The relevant sections of the Act override the terms of the lease, so it doesn't matter what the lease says in relation to responsibility for those repairs. Even if the landlord's entitled to recover the costs through the lease, it can still be prevented from doing so under the terms of the Act.
Right.
So when a request for a certificate is received, as is the case for your client here, the first thing to consider is whether or not the building actually comes within the relevant provisions of the Act.
Yes.
And that's, if it does, it's referred to as a relevant building. A relevant building is a building that is over 11 metres in height or 5 stories in height, whichever is the highest,
Yes.
and contains at least 2 dwellings. So here we know that that your building is a relevant building under the terms of the Act.
20 metres, yeah.
The next question is whether it's our client who is responsible for complying with the request to serve a landlord certificate. Sometimes that's not, always going to be an easy question to answer.
Yes.
Where there's a more complicated leasehold structure, more than one landlord, it's sometimes not clear exactly who has the responsibility for serving the landlord's certificate.
As is common in central London. I mean, I think it's not unusual, for example, on the Grosvenor estate and certain other central London estates where you have multiple landlords, potentially up to 10 intermediate titles. So it can be a complex exercise.
It can, and the definition under the Act of the person who has to serve the landlord certificate is the current landlord. Now, I'm not going to talk about that in any detail because I think that's beyond the scope of our chat today, but generally speaking, the current landlord is going to be the immediate landlord of the leaseholders who benefit from the protections under the lease, and it'll be usually the party with the repairing obligations in relation to the common parts and the exterior of the building. So given what you've said about the building that you're talking about here, it's going to be our client who is responsible for providing the certificate.
Yes, it sounds as though it's beyond doubt, especially where they have the repair and maintenance obligations as they do. What information is typically required? My client is concerned that the line of questioning is quite onerous, it's intrusive, and I think that's a fairly common observation really about what's required to be contained within these notices. What's your view on that?
Yes, it is a very common concern on the parts of landlords, because a lot of the information that they might be obliged to provide is not information that's already in the public domain necessarily. Yeah. It's much more onerous than that, some of the disclosure obligations relating to their finances. So the certificate itself, first and foremost, the landlord has to set out whether they're aware of any building safety defects. If they are aware of any defects, then they should say whether they consider themselves to be responsible for those defects, or whether there's another landlord higher up the chain who might be responsible for those defects. And then, as you've alluded to, Anna, they also have to give information about their net worth, which could potentially then include those onerous obligations in relation to disclosure of accounts and that sort of thing.
Yes.
Those questions and that information is relevant because it essentially helps leaseholders determine whether or not the landlord can then pass the costs down to it. If the landlord's net worth is above a specific value, and there's a calculation, a prescribed calculation to work out what that is, then the landlord isn't able to pass the cost down to some of those to qualifying leaseholders, and again that's a defined term under the Act.
So it's a critical question, isn't it? You know, particularly when people are selling, you know, they'll be looking for some assurances around service charges is a contentious issue at best, but looking for some assurance that they won't be responsible for the whole of the remediation costs, or indeed any, or whether certain caps under the Act apply. We've obviously have the situation now, which is very clear-cut. A notice, a request for a landlord's licence to assign has been lodged, and a request for the landlord's certificate. So when else might the landlord need to serve a certificate?
Yeah, so here there's been a request, as you say, by a leaseholder for a certificate, and in those circumstances the landlord is obliged to provide that certificate within 4 weeks. Yes. I think it's worth noting that the request doesn't have to be in conjunction with an application for a licence to alter. It can be a completely standalone request, and there doesn't have to be any other reason behind making that request for the trigger to occur.
It's not purely the assignment of the lease.
Exactly.
Yeah.
I think it's also worth landlords knowing that they shouldn't just be waiting for a request for a certificate and reacting if and when a request is received. They have to be more proactive than that, because there's actually another 4 triggers to the requirement to serve a certificate. One of those triggers is that the certificate has to be provided with any request for payment of a service charge relating to remediation costs.
Right. Okay.
And I think, you know, that's obviously understandable, given that the purpose of the certificate is to help identify whether the leaseholder should pay for those costs.
Yes.
Another trigger is where the landlord receives notice from the tenant, the leaseholder, that the leasehold interest, so the flat, is to be sold.
Yes.
That I can see being a little bit more tricky, and I think there's considerable scope for disagreement as to whether or not the landlord has actually had that notification and what information is enough to constitute notification. so as to, trigger that requirement.
And rather a moot point at the moment. I mean, the practical consequence of this legislation is there is very little guiding case law on it. And of course, we as property lawyers would say, well, exchange of contracts is when you become aware of disposal of a property, but arguably it could be sooner, couldn't it?
Yes, I mean, you could see sort of a leaseholder making an argument that actually they told a property manager that they're intending to sell the property. Almost a throwaway comment, but that is still them notifying. They would argue that's still them notifying the landlord that they're intending to sell. So you can see arguments arising in the future as to whether or not the trigger actually did occur at that particular point in time.
Yes.
And I think the advice to landlords has to be to err on the side of caution, and to have systems in place as well to help them identify when a trigger event has occurred, and therefore to alert them to the fact that they need to be serving a certificate.
So preparation is key, and to actually act preemptively to anticipate these requests as your best form of defence. As a final point, wearing your litigator's hat, do you have any tips for landlords who may have inadvertently missed these deadlines? What do you think?
Well, first of all, I would say that they're probably in relatively good company, because the Act was brought into force so quickly. There was a lot of sort of grappling around to try and work out exactly what landlords' obligations were and how they all sort of fitted together. What we don't know yet is whether a landlord can effectively remedy a breach of the certification requirements by serving a certificate late, out of time. That question hasn't yet, so far as I'm aware, made its way to the court or a tribunal. Yeah. What our advice is to landlords in this sort of situation is it's better to serve a notice out of time than not at all.
Yes.
And I think that has to be the advice. I mean, even as I've said, there could be scope for argument about whether or not a trigger event occurred, and if so, when. So it's much better to have something there that you can point to show that you have attempted to comply with the legislation rather than ignoring it altogether.
Logic would suggest that that would be a sensible way to proceed, and I think probably is your best defence in that situation. Laura, thank you so much for your time today. It's been lovely to speak to you as always about this troubling topic of the Building Safety Act. And just to add, over at Cripps, we specialise in all areas of the Building Safety Act across the entire spectrum. So please do reach out to us if you have any questions or need our help.